U.S. Marshals on the scene, she agreed one was not necessary. The Texas judge says Scalia's death certificate will read natural causes.
That was Jim Avila, ABC News, talking about more information now on Justice Scalia passing away. To talk more about all of it is our good friend, KTRS legal analyst, St. Louis University law professor, Greg Willard. Greg, thanks for joining us.
McGraw, good morning.
Unfortunately, politics being what they are, people are trampling all over the grave of Scalia, talking about who and so on and so forth. But let's talk for a moment about the man himself, a true giant, and everybody's saying that whether you agreed with him or not. Why?
Without a doubt. He has left a mark, McGraw, on American jurisprudence and American constitutional law that will be felt for decades and decades to come, irrespective of any person's ideological bent.
Right.
He is a legal giant,
I also love the fact that he is best friends with some of the most liberal justices on the court, which shows that you can disagree vehemently and yet still be best friends.
You can disagree without being disagreeable. I would recommend to anyone who has a moment to go on the Supreme Court's website and read Justice Ginsburg's words of tribute to Justice Scalia.
Right.
Remarkable. But the two of them showed, and I think the other 7 justices on the court have shown, that we can disagree significantly without being disagreeable. And he was a hallmark of that.
I'm no legal scholar, but I've read a little bit about him and talked to people about him. And in some ways, I think he's a genius. And in other ways, I don't get it. Because he says what's written is written, and who are we to interpret what they meant 200 plus years ago? Right?
By his own description, he was an originalist and a textualist. And the textualist also applies when the court interprets statute. But with his originalist philosophy, as he would describe it, he believes that the job of a justice or a judge is to look at the text of the Constitution to find the meaning. And if you can't find the specific meaning, then what was the understanding of the colonies and the framers when the Constitution was ratified in the late 1780s?
Mm-hmm.
That is the gold standard as far as Justice Scalia and many who ascribe to that school. That was the gold standard.
And in 1776, no one in their mind ever thought of gay rights or anything like that. So how do you superimpose 2016 arguments on a document that was written in 1776?
What another school of interpretation of constitutional law would say, McGraw, is that the Constitution is a living document, a living, breathing document, and it has to evolve for some of the issues that you point to. Justice Scalia, on the other hand, would, I'm sure with very colorful language,
right.
Would say, well, certainly not. For example, the Second Amendment case recently before the court, Justice Scalia said, we need to go back and see what the understanding was of the right to bear arms in the late 1780s. That's it. We don't need to talk about what the crime problem is today and what people's feelings today are about. What Justice Scalia would say is, that's all interesting, but they can deal with that across the street in Congress.
Okay, so in some ways, I get that. And then comes the Obamacare argument. And he says, who are the justices to overturn a law that was passed by duly elected people, right?
Right.
And then he comes along and says Obamacare is unconstitutional.
Well, he had there have been, and there's one case before the court this term, but on the question of whether Congress had the power to require an American citizen to buy insurance,
right.
He and several other justices said that violates the Commerce Clause. On the case, I think it was the last term, with dealing with the exchanges, the statute says an exchange established by the states.
Right.
And Justice Scalia and others said, well, those are the words they used. That's
right.
what it means. The
right.
court said, an exchange established by the states or the federal government.
Right. Yeah, it was a typo or whatever else.
Right.
But he said, look, this is what was passed. This is what we have to go with.
Right.
And that makes sense to me, but but then you go to that sodomy case in Texas where they wrote a law that said sodomy's against the law, and it was overturned, saying, hey, what's done in the privacy of your own bedroom is in the privacy of your own bedroom. And he writes, if you want to change the law, change the law. Don't tell me to change the law. You change it at your own local jurisdiction.
Well, I think on that one, I think what he would say is if you believe there is a right to privacy within the Constitution, well, then you need to amend the Constitution to state that.
Right.
And it doesn't state that, and therefore it's not our job as the Supreme Court to begin finding, as he would say, finding rights in the Constitution that have not been enumerated in the Constitution.
So we don't have a right to privacy, according to Justice Scalia, or according to originalists, because it's not in the Constitution?
You have rights to privacy, but as described and defined in the Constitution. For example, the Fourth Amendment. You have the right against unreasonable search and seizure. Now, does that constitute a right to privacy? I think you and I would probably say it does. What he would say is it is a right against unreasonable searches and seizures under the Fourth Amendment. But what has grown out of that over the years in this notion of a living constitution is this generic right of privacy, and from that have been spawned many cases, constitutional cases.
Right.
And constitutional
Do I
rights.
have a right to my privacy of my email? He would say no, because it's not written in the Constitution.
What he would say is, who is trying to get at your email? Is the government seeking to, as part of a criminal investigation? He might well have said, McGraw, you need a search warrant to get that email.
Okay, Greg Willard with us, St. Louis University law professor and KTRS legal analyst, and really interesting. We could talk for hours on this. Let's talk Bush versus Gore.
Mm-hmm.
And many people point to that as his worst decision or the Supreme Court's worst decision. It was only meant for that case and that case only, right?
Well, they stated in the body of the opinion that it was decided on its facts. I think maybe we can shatter an urban legend on your show this morning.
Please.
The urban legend is that the Bush v. Gore case, the election was stolen by the 5 Republican justices.
Right.
Let the record reflect, McGraw, that 7, not 5, 7 justices on that court found that what the Florida Supreme Court had done was an unconstitutional equal protection violation. The vote was 7-2 as to whether what the court down there had done was constitutional, and 7 out of the 9 justices said there was a constitutional violation. The 5-4 was a disagreement on the remedy. But this notion that it was the 5 Republicans huddled in the corner that found that what the Florida Supreme Court did was wrong is simply false. It's 7-2.
You have said on this show that you can't be both. You can't be an originalist and you can't be a living, breathing document guy.
I think that's fundamentally inconsistent schools of interpretation. For example, I think a perfect example is what the cacophony right now on whether the president should nominate someone. The Constitution, McGraw, is pretty straightforward.
Right.
The president shall nominate. It doesn't say may. It doesn't say he shall accept in his final term in office. He took an oath, as did the 100 senators,
Right.
to support and defend the Constitution of the United States, and it says he shall nominate. What's complicated about that?
So you're saying the strict constitutionalists who love Scalia are saying, no, he doesn't have the right to do it.
The irony is absolutely rich. He has a plenary power to nominate. The Senate has a plenary power to consent.
Right.
And that's the Constitution. As the saying goes, it ain't complicated. But in terms of then how they choose to exercise that, well, that's why we have elections.
Right.
And there'll be that give and take. But this notion that somehow President Obama is committing this grave constitutional sin by nominating someone when he is duty-bound by the text of the Constitution is just too rich, McGraw.
It's going to make for an interesting fall campaign, is it not?
Oh, to say the least. But again, I think, and we would be remiss if we did not add that in addition to a legal giant, he was a wonderful human being. And there's a family who lost a wonderful father and grandfather that's grieving. And just as the American people, I think, have suffered a great loss, Maureen and his family have suffered a great loss.
Did you ever meet him along the way?
He was in the Justice Department when I worked in the Ford White House. And so in our prior lives, and just a wonderful man back then, and by all accounts continued to be.
He was also nominated with 100% of the vote.
He was confirmed by the Senate with unanimous when President Reagan nominated him. The consent of the Senate was unanimous, and he was then appointed by President Reagan. A real tribute.
Yeah. Elena Kagan, another liberal justice, came out in saying that we lost a giant and a dear friend. So.
And again, as we were talking a moment ago, McGraw, I think it's an example that. God help us if the politicians today could just take a sliver of guidance from it. But Justice Kagan, Justice Ginsburg, and others, we can disagree, and we can disagree vehemently.
Right.
But by golly, we don't have to be disagreeable.
That's Greg Willard, and that's why he's our KTRS legal analyst, and he's a St. Louis University law professor. So if you want a good law degree, go see him, St. Louis University Law School. Mr. Willard, thank you for joining us.
Good to be with you, my friend.
827, Big 550, KTRS. Walter Knoll Florist. Let me tell you about Walter Knoll Florist, because hopefully you took my advice and you sent some flowers over the weekend to your loved ones for Valentine's Day with Walter Knoll. But that doesn't mean it ends now. Walter Knoll still has great deals. They still have hand-dipped chocolates, and they still have great flowers at a great price. So for all of your floral needs, whether it's a St. Patrick's Day bouquet or maybe it's a birthday, an anniversary, whatever it may be, let Walter Knoll help you out. A local company based right here in St. Louis. They have 8 local places, so go in there and get the grab-and-go specials they have each and every day at Walter Knoll. You can go to WKF.com, and Walter Knoll will donate money to your charity. Or you can always give them a call, 1-800-341-ROSE. Let Walter Knoll be your family florist. Walter Knoll Florist.
Amazing Siding has an unbelievable pre-spring manufacturer